So the purpose of this video is to talk quickly and briefly about the offence of dangerous driving and the options that may be open to you if you have been suspected or charged with the offence of dangerous driving. My name's Conor Johnstone. I'm a specialist motoring defence solicitor with M.A.J. Law, and I regularly represent and defend clients that have been charged with all manner of motoring offences, and in particular dangerous driving and careless driving. Now, if you've been charged with dangerous driving, then generally there's three options that are open to you. Now, before I get stuck into those three options, it's worth me telling you that dangerous driving is considered one of the most serious driving offences that can be committed. In fact, it's so serious that it's one of very few driving offences that can go straight to the Crown Court for a trial by jury. Believe it or not, drink driving or drug driving, no matter how serious, cannot be sent to the Crown Court for a trial by jury. Now, the reason that option exists in the court system is because you can receive a custodial sentence for dangerous driving, and in fact you are more likely than not to receive a custodial sentence in the Magistrates Court or the Crown Court because of how serious the offence is, and that also includes suspended prison sentences as well. But let's get stuck into it then. The first option that's open to you if you have been charged with the offence of dangerous driving, and this is perhaps the obvious option, is that you enter a guilty plea. And I guess this is the most common approach that people will take if they have been charged with the offence of dangerous driving. That's not to say it's the best option. Perhaps it's not the best option for you. Every case is different, but I'm sure that most people do just go to court. Perhaps they don't take legal advice, maybe they speak to duty solicitors, and they simply enter guilty pleas. Now, of course, there are some benefits to pleading guilty to dangerous driving, and that means that you receive maximum credit. Now, maximum credit may not do what you expect it to do to the sentence. It will reduce part of the penalty by 1/3. Maximum credit is considered 1/3 in the criminal courts, but it's only going to reduce the punitive part of the sentence. The punitive part of the sentence is the financial penalty, which you're unlikely to receive in a dangerous driving offence, the community service order, which you may receive, so community penalty, or the prison sentence. You can get 1/3 knocked off that, but you don't get a reduction on the driving disqualification. So you still get the full driving ban that the Magistrates Court or the Crown Court intended on imposing. Whether you plead guilty or not, you still get the full ban. The minimum that you can receive in dangerous driving cases is 12 months. Then every dangerous driving offence always carries a requirement to take an extended retest before your licence is given back to you as well. If your case is sufficiently serious that there's a risk of prison, then yes, it's nice to get 1/3 knocked off the prison sentence, but of course for most people the damage is done because they go to prison in the first place. Whether you spend 30 weeks in prison or 20 weeks in prison, either way, going to prison is generally what people want to avoid, as opposed to a shorter or reduced prison sentence. So credit for an early guilty plea, again, it may not have the kind of impact on the sentence that you hope for, and you still receive the full length of disqualification. The average disqualification length for dangerous driving is 2 years upwards, so it's very unlikely to get the absolute minimum of 12 months unless it's a very minor example of dangerous driving. So yes, there are some benefits in pleading guilty, and that's that you get a little bit of discount on the punitive part of the sentence, but the problem, I suppose, with pleading guilty is that you don't necessarily get to see all of the evidence against you. You're doing the prosecution's job for them because you are convicting yourself, and again, the disqualification is not reduced in any way, even to reflect the fact that you pleaded guilty at the earliest opportunity. Now, if you are considering a guilty plea, one option that might be open to you that can work extremely well in either the Magistrates Court or the Crown Court is where you try and negotiate on the facts of the prosecution's case. So here's an example. You're charged with dangerous driving, and the prosecution allege that there was prolonged bad driving. So there's evidence that you were driving for a prolonged period dangerously. Now, if that were the case and you pleaded guilty on that basis, then you are in one of the higher brackets of sentencing, and that means that there's greater harm, there's greater culpability, and you're more likely in those circumstances to receive an immediate custodial sentence because the offence is more serious. But the prosecution are always quite open-minded, and particularly when it comes to dangerous driving offences, because dangerous driving, it's a broad spectrum. There's lots of different types of driving that may amount to dangerous driving. It could be absolutely lower end, third dangerous driving, top-level careless. It could be top-level dangerous driving where custody is the only option for the court. High-speed police chase, for example, might be top-level and top of the guidelines. But again, the prosecution are always quite open-minded. So they may say, well, there's evidence in this case of prolonged bad driving. Now, what I might do if my client wants to enter a guilty plea is I'll speak to the prosecution and I'll offer them a guilty plea, but on the basis that my client did drive dangerously, but not for a prolonged period, like the prosecution allege. Now, the CPS would normally accept that because they're still getting a guilty plea. Whether my client receives a prison sentence or not, whether my client receives a 2-year ban, an 18-month ban or a 12-month ban is not really the primary concern of the Crown Prosecution Service. It's the court that imposed the sentence anyway. The primary concern of the Crown Prosecution Service is to achieve that conviction, is to tick that box to say this person has been convicted, therefore we've been successful, and that no doubt counts towards stats and success rates and quotas that the prosecution have. And so with that in mind, they normally negotiate. They'll normally allow you to negotiate with them, and that can work really well, particularly to avoid more serious sentences, prison sentences in more serious cases. If you are going to plead guilty, then at least consider the option of trying to negotiate a plea deal with the CPS. We call it a basis of plea, where we might plead guilty but on slightly different facts. It would normally be accepted, and that's going to reduce the overall penalty. As a side note, by the way, if the prosecution are being stubborn and they won't accept the basis, you can turn to the magistrates or a judge in the Crown Court, and he or she will have the power to accept that basis even if the prosecution don't, and sentence you on that basis instead. Something worth bearing in mind. The second option that is open to you if you have been charged with dangerous driving, and perhaps this is an option that I tend to lean more towards for the clients that I represent, is that we enter a not guilty plea. Now, bearing in mind what I've just told you about credit for an early guilty plea, 1/3 on the first court date, only applying to the punitive part of the sentence and not to the driving disqualification, then lots of the people that I represent see no real risk in challenging the allegation, even where they're later found guilty, because they've always got the option of changing their plea at a later stage. And even if you were to change your plea partway through the case, having, for example, seen more evidence that changes my advice or changes your mind, you don't lose that discount completely. That credit for an early guilty plea reduces from 1/3 on the first court date down to 25% throughout the duration of the case. Even on the morning of a trial, if you were to plead guilty, it's still at 10%. So between the first court date and many months later, having seen the evidence, if you plead guilty during the adjournment period, the difference is 8%. Now, 8% on a community penalty is neither here nor there. 8% on a prison sentence is neither here nor there. And 8% is not going to increase the risk that you actually go to prison either, because the difference is minor in comparison to a first court hearing. So there's no real risk in challenging the allegation, but that gives you the opportunity to check the evidence against you. Now, you may be surprised to find that the prosecution either don't have the evidence they need in order to achieve a conviction, to prove that the manner of your driving fell far below what's expected of a careful and competent driver. You might have assumed they've got all these witnesses, they've got footage, they've got this fantastic evidence, but that may not be the case. They may not have the evidence they need to prove their case to the required standard in either the Magistrates Court or the Crown Court beyond all reasonable doubt. If you enter a not guilty plea to dangerous driving, you can have your case in the Crown Court as well, either because the magistrates have declined jurisdiction and sent the case to the Crown Court for a trial by jury, or if they've accepted jurisdiction, allowed your case to take place in the Magistrates Court, then you have the option to take that case to the Crown Court instead. And most people know that the acquittal rate in the Crown Court is much higher than in the Magistrates Court. In other words, you're more likely to be found not guilty with a trial by jury than you are in the magistrates. And sometimes magistrates are considered somewhat case hardened, sometimes slightly more pro-prosecution in my experience. They prefer to side with the police than they might do a defendant. So certainly your chances are better in the Crown Court. Yes, there's other considerations to be taken into account, and that's why it's worth getting sort of independent legal advice if you have been charged with dangerous driving, but generally you do stand a better chance in the Crown Court. And even where you're convicted or you change your plea having pleaded not guilty originally, you still have the option that we've just discussed, that basis plea, where we might want to speak to the CPS and try and negotiate on the facts of the case in order to bring the overall penalty down. That's not just an option that's available to you on the first court date, that's an option that even exists at a later stage in the case. So to recap, option one is that you plead guilty. There's some benefits there, there's some credit for an early guilty plea, brings the case to an end a lot sooner, but it won't reduce the driving disqualification. There's still going to be an extended retest requirement. Option two is that we enter a not guilty plea, we challenge the case, we check the evidence. You might be surprised to find the prosecution haven't got what they need, and you can choose to have a trial by jury in the Crown Court, which increases the chance that you'll win the case because the acquittal rate in the Crown Court is higher than it is in the Magistrates Court. And the final option that is open to you if you have been charged with dangerous driving, and this is sort of similar, but a bit more extreme than the first option, which is where you negotiate on the facts of the case. And this is a full basis of plea, but to a different offence. Now, just because the police have charged you with dangerous driving does not necessarily mean that the manner of your driving was dangerous. That's the allegation. That's what the police suggest. The police don't always get it right, and neither the prosecution. And so just because they accuse you of driving dangerously does not mean that you have to accept that. The evidence may not support or substantiate that. It may be that your driving was careless. Now, the difference between careless and dangerous driving is really only a minor distinction. The definition of dangerous driving is where the standard of your driving falls far below what's expected of a careful and competent driver, and where a reasonable, careful and competent driver would consider your manner of driving to be dangerous. Careless driving is where the standard of your driving, the manner of your driving, falls just below what's expected of a careful and competent driver. So dangerous driving far below, careless driving below. Now, you may accept that the manner of your driving fell below what's expected of a careful and competent driver, but you might not accept that it fell far below. And again, that's only a minor distinction in terms of the definition of either of those offences. Now, for that reason, and again, it does depend on the precise facts of your case and how serious the allegation is and what's realistic and what's not, but for that reason, in lots of the dangerous driving cases that we deal with, the prosecution will either on a first court date accept a guilty plea to careless driving, or they will eventually accept a guilty plea to careless driving on the basis that we accept that it is top level careless driving. Now, although the distinction between the two offences is minor, in sentencing the difference is massive because the chance of going to prison for careless driving is practically zero. It's not going to happen in these circumstances, even in the most serious example of careless driving. If you look at the guidelines, prison is off the table. It's simply not an option for the court. Yes, you can still get disqualifications. Most people that are convicted of careless driving offences receive penalty points instead. And if you were to get a disqualification, it's not going to be for 12 months, and there's no requirement to sit an extended retest either at the end of a careless driving disqualification if one was even imposed. So that third option is where we fully negotiate a basis of plea with the CPS. We try and persuade them to accept a guilty plea to the lesser offence of careless driving, albeit top-level careless driving, and then we try and reduce that penalty with the right kind of mitigation to the court. Mitigation, character references, personal statements, letter of apology, etc., can all go down quite well in the Magistrates Court or the Crown Court as well. So those are three options that are open to you if you have been charged with dangerous driving. Now, what I would suggest is that you speak to solicitors. The offence clearly is very serious, and there's a lot that can be done even at the very early stages of the case to minimise and mitigate the risk of you being convicted. If you've not yet been charged with the offence, we might want to try and negotiate with the police at the earlier stages and perhaps try and persuade them to lay a careless driving allegation instead of dangerous driving. And there's a few strategies and things that we can try and do to improve those odds, as well as when we negotiate with the CPS as well. So the purpose of this video is just to skim over those options, but we do offer free initial advice to anyone that's been charged or suspected of committing a motoring offence, including careless and dangerous driving. We regularly represent clients throughout magistrates courts and crown courts across the country that are charged with these kind of offences, and also more serious offences like causing serious injury by careless or dangerous and causing death by careless or dangerous driving as well. You'll find our contact details in the description of this video, and we do offer free initial advice as well, so please feel free to get in touch. If you'd like to comment on the video or try and respond to as many comments as I can, feel free to subscribe because there's more videos coming. Thank you.